For the Second Amendment specifically, Madison started from the English law passed in 1689, also called a Bill of Rights. This document stated, quote, "Subjects, which are Protestants, may have arms for their defense suitable to conditions, and as allowed by law." The allowed by law is often misunderstood in discussions, as the intent was a restraint on the power of the king, not the government. It was not that the government could not order his enemies disarmed, but the king could not do so without the consent of Parliament, the representative of the people. Similar declarations had already been written into the Pennsylvania and Massachusetts Constitution, only rather than restricting the king, they focused more on fears of the standing army. Pennsylvania's law read, quote, "that the people have a right to bear arms for the defense of themselves and the state, and as a standing army in the time of peace are dangerous to liberty, they ought not be kept up, and that the military should be kept under strict subordination to and governed by the civil powers." Massachusetts law stated, quote, "the people have a right to keep and bear arms for the common defense, and as in times of peace armies are dangerous to liberty, they ought not to be maintained without the consent of the legislature, and the military power shall always be held in exact subordination to the civil authority and be governed by it." Again, both indicate civil power has the authority, just not the military absent the civil government's authority. All of these being concerned with the dangers of a standing army, something which was a concern not just in terms of king or dictator, but also recently demonstrated when the Continental Army nearly staged a coup. History is awkward.